Good evening. I was asked to explain the process of gathering these questions. When you registered, you had the opportunity to submit a question. Those questions were compiled by the Planning Committee. Planning Committee wrote a few additional questions. We made sure not to include questions about cases and issues that are currently pending in front of Justice Liu and his colleagues. And so the questions are not mine, but they have a little of my flavor because I had to put them in my own words. So Justice Liu, thank you so much. This is the capital defense bar in California. And we really appreciate you spending your Valentine's evening with us. This is how we spend Valentine's Day every year with each other.
Yeah. Well, thank you so much. Thanks for having me, and thank you, Michael, for all your years of service and for stepping in tonight. This is an amazing group, and the fact that you're spending Valentine's Day doing this must really show that you love the legal profession or the justice system. I think it's either that, or as my kids would say, we all need to get a life. So it's a pleasure to be here.
That's great. Well, again, thank you. So we're going to start with some biographical questions, some of which were touched on by Oscar when he introduced you. So if I understand correctly, you got into Harvard Medical School, but you ultimately became a lawyer. Did that devastate your father, who was a physician? But seriously, what made you choose the legal career?
Well, that's a good question. So let me begin by saying that it is a delight to be here, and I have to give you the necessary disclaimer that as a sitting judge, I'm happy to talk about a whole range of things, but obviously I can't talk about pending matters. So Michael told you about that, and I'm unable to offer any insights that would be in the nature of guidance or coaching to any one side or another that might advantage anybody in the cases that come before us. But with that said, I'm happy to answer the question, which, both my parents actually were general practice physicians in their careers, and I grew up in an immigrant household, very typical in many ways. My parents came to this country in the late 1960s from Taiwan, and most of their life in the States was actually lived here in California. We moved to Sacramento when I was almost 7 years old. And I guess, in terms of career aspirations, I think, my parents thought, well, be a doctor. I guess that's very almost stereotypical. Lucky for me, my older brother became a doctor, so that box was checked off. Not only did he become a doctor, he became a surgeon, which is even better. We call him the good son. I think, for me, if anything, it was just kind of limited horizons, like not knowing what else was out there. I think so many of us are just a product of what we see in front of us. And until you get into a wider world or meet some other people who can kind of, open that world up to you, you're sort of limited. And I think for me, it was just a gradual thing. I became interested in a lot of different issues when I was in college, education issues mostly, thinking about, how great educational opportunities are distributed or not well distributed, throughout our society. And I also became very interested in the diversity of our society. We used to call it multiculturalism back then. That was the term. Terms change over time. But I just didn't know how people made a career out of these interests. How do you make a career out of these interests? And then luckily for me, I had a couple good mentors who said, you really should consider law school. And so in many ways, it took me a long time to get there. But yes, my parents were initially very disappointed, but they came around.
You had a successful career in academia. What was your thought process in moving from there and saying, I'm going to be a judge? I want to sit on the bench.
Well, the longer story, I guess, is that everything I feel like that led me to this point has been just a series of unplanned things. You know, as I just recounted, going to law school was unplanned. I thought I was going to do, you know, something else more along the lines of what my parents did. And then when I got to law school, I actually thought I was going to be some kind of policy wonk. I thought I'd go work on Capitol Hill. As I said, I was interested in education policy. And I was. Those continued to be my interest for a long time. But again, lucky for me, I had some excellent mentors in law school who said, you know, you really have the wherewithal to be a professor. And I didn't know anything about it. But, you know, I went through the process and landed at UC Berkeley, which was a wonderful home for me for eight years. And I was more than happy to continue doing that. You know, I had a very enjoyable time there, teaching, writing, amazing colleagues. I see Liz is here, one of my colleagues. I didn't set out to be a judge. And so what happened, I think many of you know, is that when President Obama was elected in 2008, I began to get a lot of inquiries from different groups who compile lists, you know, for people to nominate for judgeships. And they said, "Can I put you on a list?" I said, "You can do whatever you want." You know, lists are cheap. But eventually, you know, over time, this became more. And then I was eventually nominated for a seat on the Ninth Circuit in 2010. But that nomination was unsuccessful because I was stalled in the Senate in 2011. And back then, you needed to get 60 because there was a cloture requirement in the kind of internal norm at the time. That eventually got blown up. But I withdrew, actually. I thought there's, you know, I didn't set out to be a judge. Anybody who looked at my sort of written history knew I didn't set out to be a judge. But then, you know, the story, I'll just tell you this, you know, as kind of the last bit. The very day after my failed cloture vote in the US Senate, I was back in my office at UC Berkeley. I had been in DC that week to meet with senators and do the last minute things to try to twist arms, whatever. That was unsuccessful, very disappointing. And then on the Friday, I was going to my office. I had just dropped off kids at school, turning the handle to my door, and the phone is ringing already. And so I pick up my phone, and who is it but Joshua Groban, who at the time was the appointments secretary to Governor Jerry Brown. And he said, "Well, I see your fortunes have changed." And he said, "Would you be interested in a conversation about the California Supreme Court?" I said, "Sure, I'd be interested in anything right now." And he said, great, we'll call you back." So 30 minutes later, the phone rings again, and this time it is Governor Brown personally, which kind of took me aback because I don't know him. I mean, I've never met him, and I didn't have any other personal relationship with him. And he said, "Well, so you're interested in the California Supreme Court?" I said, "Well, I became interested about 30 minutes ago." That's true. And he said, "Great, meet me in my Oakland office at 1 o'clock today." And I said, "Wow, that's amazing. You know, what a reversal of fortune, you know, in 24 hours time." So it was a Friday at Berkeley, and very few classes are taught on Fridays. So I'm sure I was wearing like a shorts and a t-shirt. So I had to go home, get cleaned up, get dressed. And so I go to meet him and his wife, Ann Gust, who is a very formidable lawyer in her own right, and their dog at the time, Sutter, who went with them everywhere. And I meet the three of them in an Oakland office. He, of course, used to be the mayor of Oakland, so he kept a home there and had an office there. And I still remember we were sitting on this, you know, at this table. He had this big binder, which was all the stuff that he knew on me, you know, all the clippings from the Ninth Circuit stuff and my writings and all this stuff. And he just pushed it aside. And he said, I'm not interested in any of that. And so he began the interview by saying, I have one question, which is, what do you think is the basis of law? And I was like, what? I had just been through this process where, senators ask questions like, what do you think of the death penalty? Or what do you think of, Roe versus Wade? Or whatever, all questions that have the same answer, which is, I will follow the law, right? And so he was really interested in some very basic things. So for 2 hours, we talked about social contract, we talked about natural law, we talked about the common law, we talked about how, the common law has fared in the age of statutes. We talked about the administrative state and how that came to be, and all kinds of stuff. Anyway, for 2 hours this went on, and at the end of it I said, Governor, this is great, but are you really interested in me, as a nominee? Because I'd just been through this unpleasant process. It's hard on the family, all this stuff, and I don't want to do that again. And he said, well, I am very interested. And then I hear nothing for 3 months, crickets, completely nothing. And I don't do anything. I don't even know how to lobby him if I wanted to lobby him, but I did not lobby him. I did not press my case with him in any way. But then 3 months later, I get another call from Joshua Groban and says, the governor wants to see you again. And we do this exact same thing, same place, the three of them, him, his wife, Sutter, and the dog, and the three of them are interviewing me. And we have another 2 hours about, all the philosophers and, the natural law, Rousseau, Montesquieu, Locke, whatever. I mean, he's incredibly erudite and just very eccentric in terms of his intellectual interests. And I mean, he reads law review articles. I was like, Governor, even law professors don't read, all these law review articles. Like, you have a state to run, Anyway, he's just a very wide-ranging intellect. And I walked out of there thinking, this is crazy. This is not even a judicial interview. Like, I don't even know what this is. This is a political theory seminar. And then like 3 days later, he called me and he said, I'm ready to appoint you. And I was just absolutely floored. So that's how I became a judge.
That's a wonderful story. Thank you. Just two quick things. You cleared about 3 of my later questions.
Oh, sure.
So that's awesome.
Well,
and also my interview with Governor Brown when he appointed me for my 3rd term as state public defender was a little different. He was wondering why I went to Cal State Long Beach instead of a better school. So when you say erudite, I think that's about right. Yeah. He was very sweet.
And he appointed you.
He appointed me. That's right. So let's dial back a little bit and how, if it did your coming from an immigrant family background affect your career path and your choice to go on to a judicial career?
That's a great question, because it's one that I'm still thinking about. I do a lot of work on diversity in the legal profession, research-wise. I lecture, I teach, I give talks, trainings, those kinds of things. And it's still a work in progress, I think, for me to understand the various ways in which, a kind of personal history might shape one's outlook on life. So I will say that, so really going far back, I was born in Augusta, Georgia, of all places, because my dad at the time was a fellow at the Medical College of Georgia, which is a very good research institution. And that was in 1970. I was born in 1970. And then we lived there for 2-3 years, and then we moved to a very small town in the south of Florida, which I'm sure that 95% of you probably never heard of, called Clewiston, which is just north of the Everglades on the southern tip of Lake Okeechobee. The nearest big city is called Belglade. That town has like 10 or 15,000 people. I grew up in a town, close to about 5,000 people. And it was an interesting life because I'm sure we were the only Asians in these places. I mean, these were largely black and white communities with a significant population of Native Americans. So there's a large Seminole population in this area as well. And growing up, as a kid, I knew that the Florida town, Clewiston, was segregated. I knew that just because there were references made to the black part of town, the white part of town, and there was an Indian reservation as well. I became later interested in all of these things because my research focus was a lot on school segregation, and I ended up teaching constitutional law, so that necessarily draws you in to the history of America and necessarily also draws you into a lot of civil rights history. And through my own research, learned that Augusta was, of course, also segregated for some period of time. And the first court orders that went into effect to integrate the schools, both in Augusta and in South Florida, were within my lifetime, in the 1970s. And that definitely lent a little more color to the way I teach this material now, because, it's often the case we think that civil rights history is history, but, I don't think I'm that old a person. This is all, within my lifetime events. In fact, the elementary school that I went to when I was in Florida was integrated, I believe, just 2 or 3 years before I attended. And so these are not obviously I was too young to have any thoughts about it at the time, but these are all things I later kind of discovered. And I think that I'm not even sure yet, how my family's immigrant story fits into this largely black and white paradigm of the American South. But that too is kind of an interesting puzzle. But the common denominator, I think, is that having that history does give you some sense of what it feels like to be an outsider looking into the mainstream of society. And I think that is the genesis of virtually all of my interests, that have arisen both in my academic career and, just in my own personal life, is how does this country, make outsiders into insiders. I think that is the history of this country, and I think I participated in it in some small way myself.
Well, that's very interesting. We, spend much of our careers working with our clients and developing their stories and telling their stories. And one story that I found really compelling that your court took up in 2015, and I'm told I'm allowed to talk about this, so no one get worried. I'm not breaking any rules. Is the Hung Yan Chang matter?
Yes.
Mr. Chang, for those who will remember in the audience, was denied admission to the California State Bar 125 years ago.
Yeah. So Hong Yan Chang was an immigrant from China who actually first passed the New York bar. I think he was one of the first persons of Asian descent to pass a state bar exam. And he eventually sought licensure here in California. He met all the requirements. He passed the bar. He had good moral character, all these things. But he lacked one thing, which was citizenship, which was impossible for him to obtain because the Chinese Exclusion Act of 1882 forbade persons like him from being U.S. citizens. And so our court, in a published opinion in 1890, denied his licensure. And you can read it. It's in the books. And it explains what the requirements for being an attorney were at the time and the legal obstacle that he basically faced. Well, what happened was very unusual. We got a petition from attorneys working with students at UC Davis Law School. I love that part of the story. Who represented essentially the descendants of Hong Chang, who sought his posthumous admission to the bar and explained, this whole situation. And, this is pretty unusual. I don't think we had encountered something like this before. And it was agreed, all of us who were on the court at the time, that we would publish an opinion granting this request. And it was, normally bar matters come and they're handled through, simple orders. But we felt it important to have a published opinion that kind of carried the same weight, if you will, as the published opinion that had denied his admission previously. And that opinion, I think, was really quite amazing. I think the one, well, you can read it. It's not very long. But the key thing that I think it says is that, we can't undo these parts of history. But what we can do is we can honestly confront it. We can acknowledge it. We can recognize that it happened. And then posthumous admission, of course, is a symbolic thing. It doesn't undo what was done. But it can be a powerful emblem, right, of the world that we think should have been and that we can make now. And I think it still remains, one of the most meaningful cases that I participated in my time on the court.
Yeah, I will just add that, and who am I to add anything to that? It's so beautifully said. The court referred to what they were doing as a candid reckoning with a sordid chapter of our state and national history. They referred to what happened to Mr. Chang as a grievous wrong. And they said his posthumous admission to the bar will affirm his rightful place among the ranks of persons deemed qualified to serve as an attorney and counselor in the courts of California. Excuse me.
Thank you. Yeah, thank you.
Yeah.
I mean, it was an emotional case, and in fact, I remember we had a couple gatherings actually with, and I can't remember if it was the descendants or the attorneys, the students who worked on this case, to acknowledge, basically what had happened. I think it's important. One thing I want to point out, which the opinion talks about, which is that although the Chinese Exclusion Act was, the barrier, California, of course, played a very big role in all of this. So this is not just federal history, this is our state's history. And you can consult that opinion or others so that you could see that in our 1879 Constitution, the sort of precursor to to our modern Constitution in the state. First there was the 1849, but that was the old one, and then it was updated by a convention in 1879. That Constitution includes a section, right? It's an Article 19 of that Constitution entitled Chinese. And it just writes into the Constitution all the disabilities, right, employment-wise, labor-wise, voting-wise, that are to be visited upon, persons of Chinese descent, and it's in the Constitution, right? And that only later, obviously got taken out. So this is all part of our own kind of state history. I don't want to suggest that it was the big bad, federal government that did all this. I mean, most of the things that Congress did at the time that were anti-Chinese were very highly motivated and supported by people in California.
Great, thank you. So the second half of the questions, I assume, were written so that folks can get their MCLE credits for today. And
Okay.
so they're a little bit more mechanical about
Sure.
the court and its operations and how you see judicial decision making. So do you have a general philosophy regarding your judicial thinking, your judicial decision making?
Yeah. Well, I think, so I've been on the bench now 14 years. It's hard to believe. Can't believe it's been that long. Everyone always asks you, do you have a judicial philosophy? Yeah, get it right. Follow the law. I think that that's real in the sense that I'll give you this perspective, which is coming as I did from being a professor to being a judge, I realized a few things. As a professor, I think it's very interesting, of course. You study the law, you teach from big case books, you write a lot of, theory about, what the courts are doing right, what they're doing wrong, how they should do it better, this kind of thing. As a judge, I think you realize pretty quickly that a lot of that doesn't really help. Judging, in my view, is a very practical type of enterprise. You can talk all you want about, all the different theories of interpretation or methodologies, etc. But at the end of the day, if you're a court like ours, we have a lot of precedent. We have a lot of statutes. We have a lot of authorities, that we simply have to work with. And very few questions come to us, if any, that are simply, tabula rasa, like, go to town, figure out from first principles, what the meaning of X is. There are very few questions in the law that arise in that posture. And so being a little too attached to one kind of theory or another just, I think, doesn't really help that much to solve, problems in the law that arise that are basically presented in a fashion as good lawyers present them, which is good lawyers look far and wide for all kinds of resources that may bear on the correct resolution, of a particular case. And I think my observation, at least for my own court, is that of all the justices that I've served with, and there have been many at this point, I'm like a geezer on the court, I'm like an old timer. None of them were methodologically doctrinaire in any way. We all considered everything that people argued. We considered all the different sources. And this, I think, generally made for very practical and, dare I say, somewhat more commonsensical resolution, of matters.
Well, if I can follow up a little bit on that. When the principles of stare decisis and maybe the evolving standards of decency or some other new legal principle collide,
Yep.
What's your judicial approach? How do you
Well, there are actually, there's plenty of guideposts in the law about such things. Stare decisis is a doctrine. It's not a command, it's a doctrine. It's a doctrine that says, generally adhere to precedent. But you need to consider a variety of factors that bear on your adherence to precedent, including, whether there have been changes in the legal landscape, including whether the rule has proven to be unworkable, whether it has been shown to be impractical in some way. There are other factors, and I think you need to actually kind of think about the case that's being made for departing. So you can think of it as a very, very heavy presumption, which it generally is and generally carries. We try as much as possible to make the law, whole. And I think that's worth dwelling on for just one moment, because some people might ask, well, why do you need to do that? Isn't it better to just kind of, get things right? whatever that means in a particular case. And I think, as I've served longer, I can see the value, which is that the rule of law in our society depends on a degree of confidence in its continuity. Its continuity is in part, right, an aspect of its impartiality, the linkage of things in the past to things in the present helps to show, right, that the rule of law is not dependent on, who the judges are, but rather that it emanates from something a little more institutional and something a little more considered. And I think, of course, people criticize this, and you can criticize it, kind of this way or that way based on, particular examples of cases you like or don't like. But in the main, I think that this is an important principle. And without it, I think we'd have, I'm not sure what the rule of law would really mean if we didn't have a principle like that.
You famously write more dissents, I think, than any of the other justices on your court. And you don't just write dissents, you write dissents. They're full-throated dissents. I feel like my mic is going off. Oh, sorry about that. Can you talk a little bit about what you think the importance of a good dissent is?
Mm-hmm.
And is there a dissent from your court or from another court that you find good as an example of how you are able to change the direction of the law based upon dissenting?
Yeah. That makes me sound like I'm a very disagreeable person.
I didn't mean
No,
that.
no, I know. Let me first of all, let me put the notion in perspective a little bit. I often chuckle a little bit when I'm told that I'm the most frequent dissenter. I think that may be statistically provable, but it's in the context of a court that agrees most of the time. I mean, when I say most, I mean really most. Our unanimity rates are sort of in the 80% range, right? So when we're talking about writing dissents, I haven't looked at my numbers recently, but to be the most frequent dissenter in my court is really not saying very much. In a year where we may issue 60, 70 opinions, I may, dissent a handful of times, right? So that already makes me one of the most frequent dissenters in my court. But, you need to compare that with other courts in terms of frequency. I just want to put that in perspective. But it is true. So it makes me think carefully about what I'm doing when I'm dissenting, because we don't really actually have a very strong norm of dissenting in my court. And I think I have actually evolved. I think when you first get on the court, you sort of feel a little bit more like, I'm here to kind of, I'm here to, give my independent point of view. And I want that, to be known, whatever it is. And you feel a little more gung-ho about those kinds of things. So I think early on, I did write probably longer dissents, maybe more dissents. But over time, I have come to feel that one needs to guard against a few things. First of all, I will just say, dissents are a little bit like vanity projects, or at least they carry that risk, right? It's fun to listen to yourself talk, It's fun to hear what you have to say, right? Especially to yourself. And how fun is it to actually write it down and get it put in the books, right? But that's not a very good motivation for dissenting, right? So one has to be realistic and a little sober about the idea that, is this a vanity project, right? Secondly, I think one has to, pay some attention to the idea that dissents can be kind of irritating to your colleagues. Nobody likes to have, a 30-page dissent thrown at them with this, that, and the other thing. Okay, That's part of the give and take of what it is to be on a multi-member court. But if you do it all the time to people, right, like that can be a little wearing. So you have to choose carefully, when you're going to do it. And then third, I would say, these are kind of the screens that I apply. Third, I would say, is that you have to have a point, meaning what do you hope to accomplish, right? Other than just kind of venting your spleen, which is sometimes necessary. Sometimes you just think, all right, as a matter of principle, like this is wrong, I've got to say it. But it's better, I would say, if you have some thought in mind about who the audience for your dissent is and how your dissent might actually yield something productive. I have been, you asked for examples. I mean, I guess I'll just say I've taken a cue from my old boss, Justice Ginsburg, who I think was famous for her dissent in the Lilly Ledbetter case, which was about pay equality, right? So she dissented from a decision of the court in which she wrote basically, well, I would interpret the statute differently with regard to pay equality, and now the ball is in Congress's court. And then, of course, Congress then passed a law, overruling Ledbetter, and it was the first bill, I think, that President Obama signed when he became president, right? Well, I've done that a few times, which is to say I've, pointed out things, and we have a very active legislature in California, some would say overactive. From time to time, they actually read the things we write, and they have taken up issues that I have flagged, not just me, but other justices too. And so that has resulted in some legislative changes, and I think, I've been happy, when that happens, because it felt like, okay, like that made a difference, and I had a point. So those are, I think, the better examples. I'll have to look at my numbers now that you mention it. I think I've dissented less, actually, in the last few years, based on the kind of evolution that I've.
Oh, we like it when you just makes us feel good. Usually. So the role of oral argument in judicial decision making. Can you talk a little bit about that? Maybe this will be the lightning round.
Sure.
And especially, does oral argument matter really?
So I'll go quick. So oral argument, I think, matters no less or no more than it does in any appellate court, in ours as in any appellate court. That is to say, right, that appellate practice in America in the year 2025 is largely a written enterprise, right? We are well past the day of Chief Justice Marshall and the old reporters, where if you open up the old, Cranch reporter, you will see it says things like, Mr. Smith for the appellant said, and then all these arguments, and then Mr. Jones for the appellee said all these things, and then the court opinion issues from there. That is because in the olden days, they didn't have Microsoft Word, right? They came to court, for hours, if not days, orally presenting their arguments, and then it was recorded by the court reporter and then summarized into the judicial opinion and reported. Well, of course, that's not how we practice appellate law today, right? And because of the modern tools of research, most everything, that gets argued in the case is written. And then that written work is, of course, analyzed by the judges involved in any case. And so oral argument is just a sliver of the deliberative process that the court undertakes. But of course, it's an important one, and it's the one that's in public view. So people tend to think it's very important because it's the one in public view. It is important, but what I want to say by giving you this context is that it should not be thought overly important, because if it hasn't been argued in the brief very well, it's very rare that an epiphany happens at oral argument, right? So just keep that in mind in terms of the relative thought of, relative weight that you think oral argument might have as against, written briefing.
You brought up briefing, so what are your pet peeves, if any,
Pet peeves.
that will inform us to avoid in our written briefing?
Yeah. Well, I like briefs that have a lot of plain English in them. I like it when attorneys aren't afraid of the reasoning behind their arguments, which is to say, long citations to authority and recounting of lots of cases, sometimes it's necessary. But what you really want to convey, and a good exercise is, of course, like the summary of argument in any brief. Can you write that without citing a single case, without citing anything? Just write it in plain English, keep it short, and explain it as if you were explaining it to a friend, who was a layperson. And that, I think, is a good way of disciplining, what you say. I also think that I'm not a huge fan, this is totally personal, I'm not a huge fan of footnotes. I don't like bobbing my head up and down on the page. If it's important enough to put in any piece of writing, put it in the text. I learned this from my other judge, whom I clerked for, who is David Tatel on the DC Circuit, recently retired. He wrote every opinion without a single footnote. I have done the same, save for one, which was early in my tenure, and I was led astray. But since that time, I have written not a single footnote in any of my opinions. And it is not only possible to do that, I think it's good to do that because it makes you think very carefully about the line of argument that you're pursuing or the line of explanation that you're pursuing. And footnotes can clutter your document, and they can, what is a footnote? A footnote is like something that someone doesn't know where to put, and so they stuff it into a footnote. Well, my thought is, I tell my clerks this, think it through. Where does it belong in the argument? And put it there, right? So that's you asked for pet peeves. That's just me.
That's great. Supplemental briefing requests. We get an order in one of my offices for supplemental briefing, and we scramble. It's all hands on deck. We're going to win this case on this supplemental brief. Can a single judge require a supplemental brief, or what's the process there?
Well, first of all, let me say, I feel for all of you who get these orders from us. As you know, many of our cases, including the capital cases, go on for long periods of time, so new issues arise, and we're constantly, it's like just keeping up. Internally, so I'll say, the court, of course, has to agree to supplemental briefing, but generally speaking, we're pretty kind of responsive. If somebody in other words, if somebody wants to know more about an issue, we're not going to, deny a well-meaning, good faith, interest among one of our colleagues who wants to hear about an issue. We do, we try to be very careful about how we craft the request because we don't want to take the case and the parties sideways into some different case and make the case into something it wasn't. So we do try to be very careful. I think at this point in many of our capital cases, because the legislature has done lots of legislating in the criminal justice space over the last several years, we have had in some of our cases multiple rounds of supplemental briefing, and this can be challenging for all of you, and believe me, it is very challenging for all of us.
Okay. Can you talk a little bit about, I'm trying to word this in a way that's not viewed as criticism, the time it takes
Go for it, Michael.
Thank you. Completing the briefing on the case and oral argument.
Yeah.
There seems to be a huge gap there. Yeah. And we're just wondering perhaps if you can enlighten us about that gap.
Look, I think it's no mystery that the court has a large backlog of capital appeals. I haven't looked at the data in recent times, but given the magnitude of these cases and the large number of them, I assume the basic picture has been fairly constant during my time on the court. It's a constant balancing act for us. So we have review granted cases and we have automatic appeals. We have a central staff of attorneys who help us with capital cases solely. So we do have a capital dedicated staff. And we process them and analyze them in the regular course of what we do, balancing that against the rest of the docket. Now, after serving for 14 years, I probably feel like I could do capital appeals all the day as long and still not make, a huge dent in it. And that would be to the neglect of all the other issues, right, that the people of California expect us to resolve as well. So, I don't know. I think I understand it's a point of frustration for a lot of people who have to wait a long time, and then it leads to even more because of your previous question about supplemental briefing. So I don't have a great solution for you, and I think that is part of the challenge when you're in a big state that has a very, very large, still large, capital inmate population, and these appeals require a lot of care because obviously the stakes involved, and just the massiveness of many of the records that we deal with in the tens of thousands of pages, right? So,
I can think of one solution, but I'm not allowed to talk about it. Just, it used to be that when someone petitioned for review, we would see the breakdown of the votes. And then that practice went away.
Yeah.
And it was kind of informative to us because we could note whether there was an issue with maybe if we had slightly different facts, we could push it from 3 to,
Yeah.
Yeah.
Well, that's interesting. So we do have a practice, as you know, of noting dissenting votes when there has been a denial of review and some justices feel it should be granted. The justices can ask to be noted. That's what we say. Please note me. And then I also have, from time to time, as have other justices, written little dissentals from denials of review, or sometimes there are concurring opinions, actually. I've done that too. I agree that this case isn't a good vehicle, but, this issue is important and we should keep an eye on it. Something like that. I think that those have hopefully given a slight bit of transparency to what's going on. But, I understand what you're saying. I think one of the very important functions of our court is deciding which cases to review. And there are probably some arguments that have been made too about the U.S. Supreme Court about transparency in that process. So I don't know, it's something that I would be open to hearing more about. I haven't thought it through in terms of what all the implications of that would be, in terms of, if those were all recorded votes, how would that, first of all, how would that even work in terms of, how we do things procedurally, and then how might that affect people's, views about the time it takes in terms of reviewing cases and the kinds of things that they want to do in terms of explaining themselves and these kinds of things. So there's probably a lot of ramifications of that. But I'm one of the reasons that I mean, this is sort of me again, not knowing what norms I'm kind of stepping into or not. When I wrote the first dissent from a denial of review, I think it was in 2015, 16. It was the juvenile Miranda case. I think some of you know it. I guess it was the first time any justice on my court had done that in 60 years. And I thought, that's wild. You mean no one has explained themselves in 60 years? Like why they decide, So I just thought, I'm not trying to make a habit of that. I write maybe a couple of those every year, maybe 2 or 3. But I think from time to time, it's good to say something so people know you're paying attention and that something is important.
Many of us work in agency offices, state employees, county employees. And since the pandemic, there's been a lot of discussion about how to balance remote work and perceptions of productivity. And I'm curious if the court has wrestled with those same issues.
Sure we did, and we have. So, our court actually, I think, remained remote for longer than some other courts. And I think that experience certainly has had some, it has taught us a few things. So our current practice, I think some of you may know, is that we do allow remote appearances by counsel now if they choose. Some courts were actually ahead of us in that. I remember visiting the Colorado Supreme Court long before the pandemic, and they had long ago permitted remote appearances because of the weather. I mean, they just had like logistical challenges in Colorado, and they didn't want people to be unsafe or worry about, those kinds of things. And so they were used to having remote appearances, and we are now too. I mean, we don't ask, we don't really ask people like, why do you want to be remote? We just give them the option. If they want that, they can have it. And it works pretty good. I mean, I think, the technology is good. I would say in terms of our overall work culture, so like many workplaces, we are not a 5-day-a-week in the office court anymore. We are 2 days in the office. And because appellate work is largely on paper, most everything can be done remotely. That is not to say that all of our functions are remote, so I am very thankful for the incredibly diligent work of our clerk's office, many of whom go to work every single day. And that's something that we should appreciate and acknowledge. And for my law clerks, I've now had 4 or 5 rounds of law clerks since the pandemic. And I must say, young people, such as they are incredibly adaptable. They can, they're just, this is like nothing to them. Many of them have never worked in an office. Mm-hmm. They don't know what it's like to work in an office, right? And so I just think this is in part just part of our changing society. And the pandemic obviously was a tremendous tragedy on so many different dimensions. But on other dimensions, it did open us up to some possibilities. And some of those are even further being explored in terms of, how the justice system can be made more accessible more generally to the population, right? I mean, the notion of, whether you can take care of, everyday matters, whether it's a traffic ticket or a custody issue or whatever it is, whether some of those things, right, can be handled without people taking an entire day off work, without pay, without having to find childcare that you don't have. I mean, there are many things that we ought to think about as a society using technology to make the justice system more accessible.
Fascinating. One of the questions that came from the registrants was one that I wouldn't have thought to ask. Do the California Supreme Court justices interact with justices from other states? And if so, which is your favorite state to interact with? No, that last part I'm joking about. Just joking about that.
I do. I mean, I do, go to conferences and, I accept speaking engagements. I try to be available, because I think it's enriching for me. I learn things, from other courts' practices, There are many, many multi-member courts throughout our country, and it's useful to know that the way you do something is not the only way of doing something, and you can actually learn things from other jurisdictions. I also think I'll tell you one thing that I think is really good, which is that although there's a lot of talk about politicization of the judiciary and things like that, by and large, whenever I've gone out and about, whether it's meeting other state judges or federal judges, and I participate in organizations, and I see lots of these people. I think everyone has a strong sense of their professional norms. Everyone speaks the same language. We are part of a sort of professional culture, a legal culture, that I think if the public knew more about, they would actually find it reassuring, which is to say, judges generally think of their job as being judges. Not policymakers, not politicians. We are judges. And I think there's something culturally kind of important about that in terms of how we think about things, how we carry ourselves. Just the notion that, when you're a judge 24 hours a day. Everyone lives under those same constraints. And we understand that, something deeply. So regardless of, kind of our backgrounds, where we came from, whatever our points of view are, we share, I think, this professional ethic. And that, I think, has been a very valuable part of getting out and about, is just knowing, that there is this kind of, a kind of community, if you will. And that's useful because, as I said at the outset, as judges, we're very limited, actually, in what we can actually talk about. And so to be able to share, the things that kind of not cases, but just the work challenges, that we have with other people who do the same work, again, regardless of people's points of view or whatever, is just an incredibly valuable thing.
That's great. Thank you for that. And with a final question, as I see our time is ticking down, and it's a big one, but we'll take as much time as you want to talk about it. Can you talk about, from your perspective, the importance of diversity on the bench and in the state bar? California's Supreme Court is incredibly diverse, but that's not always how it was, and we're just interested in your thoughts on that.
I've had the amazing privilege of serving on a court now under 2 women of color Chief Justices. First, Tani Cantil-Sakaue, amazing person, learned so much from her. And now Patricia Guerrero, also a tremendous leader, outstanding temperament, very smart. I've served every one of my 14 years on a majority-minority court. When I first came on the court, I think it was significant that I was an Asian American who got on the Supreme Court, but I quickly realized there were 3.5 Asians on the court, or in that complement. There was me, the Chief Justice, Ming Chen, my colleague from Alameda, and Joyce Kennard, who was half Chinese, actually. Her family traces to Indonesia. And then over time, it has changed, into various configurations. But I live in a little bubble in that way because I understand that most courts don't exactly look this way. This is my personal experience, but I think it is incredibly enriching to hear these multiple perspectives. And I'm not saying that it's this is a Latino perspective, or this is a Black perspective, or whatever. In fact, I think the most interesting part is that people bring their entire life experience, of which, their various identities is one part. And if anything, it tends to dispel stereotypes about all people like this think one way or all people like that think the other way. I mean, if you hear the things my colleagues say, it's like they have such a range of views. I don't go around predicting actually what they're going to think. And that, if anything, is like a tremendous lesson. Last point I'll say is that I always thought Justice O'Connor got it right when she said in the 2003 affirmative action decision that maybe, in her view, the most important thing is that the citizenry has some expectation that its leaders will be reflective of their of them. And I'm not saying that's like a one-to-one correspondence, but I just think that the justice system in particular depends to some degree, right, on the makeup of our leaders, judges and others, looking somewhat like the citizenry that we hope to serve. And that, if anything, goes to the very heart of public confidence in the justice system, which at the end of the day is really all we have.
Thank you, Justice Liu. I really appreciate your candid comments, and we appreciate you coming and joining us here at CCDS. Truly, thank you.